domestic arbitral tribunals and courts have to learn from evidence taking and, I might say, other procedures in international arbitration. Our speaker today is Professor Alejandro Garra. He's Argentina originally, was educated in La Plata, went on to a master's and PhD in the United States and is now a professor at Columbia University, but that's just his day job. He then travels extensively and lectures in a number of universities around the world. He's written extensively on arbitration, and he's going to speak to us today on evidence taking, but that's perhaps tip of the iceberg. He's going to speak a little bit more widely on arbitral processes generally, including the disclosure of documents, procedures generally, harmonising the expectations, shall we say, of counsel and parties from different jurisdictions, and then he'll tell us about the taking of evidence, giving of testimony, and I'm going to also ask him a couple of things about how they control the timetabling of hearings, which is, in New Zealand we tend to take as long as it takes for a hearing, whereas when you're gathering up parties and counsel and tribunal members from all around the world for a specific time, it's important that the process finishes on time. So hopefully the Professor will talk to us a little bit about that towards the end. Thank you. I'd like you all to welcome Professor Alejandro.
Thank you very much, ladies and gentlemen, and thank you very much, Mr. Sissons, for your kind introduction. It's true that the subject of my presentation here is focusing on taking of evidence, but of course evidence is part, or generally understood to be part of procedure in general. So much of what I'm going to be saying about the evidence-taking idiosyncrasies in international arbitration applies to procedure in general. On that point, I must emphasize that one of the interesting aspects of what I find could be of interest to you in my presentation is to highlight what is peculiar of the international arbitration that you don't find in domestic arbitration proceedings, which is the area in which I understand many practitioners are most familiar with. In the first place, the idea of arbitration or commercial arbitration to be international. International is not something widely understood. It may be understood in different ways. I think that one good guidepost is the definition itself of international commercial arbitration in the New Zealand Arbitration Act of 1996, which is taken from the model law. And Section 1, Paragraph 3, subsection B, refers to as an arbitration being international when the parties are domiciled or have their places of businesses in different countries, or when a significant part of the performance of the obligation of one of the parties is outside the seat of arbitration, or alternatively, when the parties expressly agree that the subject matter of the arbitration it relates to more than one country. But I think at the core, what it makes an arbitration international is the fact that at least the law of more than one country is likely to be at stake, or that the arbitration itself, be because of the parties or the performances of the substance of the transaction, is to take place in more than one country. And when I take a more than one country, I mean also that it may involve a different language, different legal cultures, different procedure, different substantive law. That, I think, is what is distinctive of an arbitration that is international. So the question when we focus on what type of rules should this arbitration be subject to, I think that the instinctive response is that there should be international rules. There should be national rules. There should be rules that go beyond the peculiarities of one domestic, municipal, or national law. And I think it's appropriate for me to quote, and I kindly thank Mr. Sissons for having me facilitated a book on arbitration in New Zealand, which was the product of, or preface, is introduced by what I see in New Zealand enjoys much respect. One is a quotation from a case, which is what happens in other countries, and secondly, if it quotes from an important judge. And in this case, it is the House of Lords, the court, and Lord Wilberforce, the one who is being quoted. And he says, talking about the adoption by the United Kingdom of the Arbitration Act, he says, I would like to dwell for a moment on one point to which I personally attach some importance. And he says, I have always wished to see arbitration as far as possible and subject to statutory guidelines, no doubt, regarded as a freestanding system, free to settle its own procedure and free to develop its own substantive law. And I think this is the idea of arbitration, international arbitration. It should have its own rules of procedure. It should have its own substantive law. Whether it would ever be its own unique international, really, and national substantive law is a matter to be said. Much of what the discussions, the group which I am part of on the CIG is precisely discussing this specific uniform law on sales and whether or not we can achieve a uniform interpretation or meaning of that statute. That is difficult enough. But I think it's even greater challenge is to get to a uniform procedural law governing all these international arbitrations. And that is certainly quite a challenge. First question then is, which law do we have in international commercial arbitration of a procedural nature? And the fact is, we have none. We don't have a pre-existing code of international arbitration. Actually, at one point in history, it was the procedural rules applicable to domestic litigation in the seat of arbitration, the one that was applied. There are very few jurisdictions that still adhere to that view. Most legal systems today have their own rules of procedure applicable to arbitration, and they are not linked nor influenced by the domestic rules of procedure applicable to litigation. Now, one important question is that if we don't have a pre-existing code of international arbitration, what type of rules should we have then? And I think that enforces us to think about what are the parties' expectations. What do you expect when you enter into a dispute with a party which is not only new and not a New Zealander, not a common law jurisdiction, with a completely different background and legal culture? What do you expect to have if you ever were to be drawn into a dispute with that party? Well, probably to be in a neutral seat, with neutral law. And actually, that's what the approach of most legal systems today is to arbitral procedure. They should be flexible. They should be tailor-made to the nature of the dispute and to the needs and convenience of the parties. This is why, if there is a golden rule, actually widespread all over in the arbitration world, is party autonomy. The parties enjoy almost absolute freedom to choose the rules of procedure applicable to their arbitration. That is the example, Articles 18, 19 of the Uniform Model Law strongly provide for that. Now, it's true that the relevance of respecting this party autonomy is shown in many aspects, not only in the national arbitration laws of New Zealand and of the arbitration rules of most institutions, but it's also shown in the international treaty governing most enforcement of arbitration awards all over the world, the so-called New York Convention of 1958, of which New Zealand is a party. That convention, Article 5, paragraph 1d, provides that one of the reasons or grounds for rejecting the enforcement of an arbitral award is if the arbitral tribunal failed to respect the agreement of the parties. And therefore, it is important for any arbitral panel to actually pay heed to the arbitrators, to the parties' provisions on what they have agreed for the procedural rules. Now, I said almost full party autonomy. There are exceptions, as in anything else. What are the exceptions to this almost free range of party autonomy? Well, generally the mandatory rules of the forum or the mandatory rules of law of the place where the award will sought to be enforced. And this is important because if there is a way of challenging awards of an international nature, there are two important ways of challenging it. One, an action to set aside, generally taken in the place of arbitration and before the courts of the seat of arbitration, and the other one in the place where the award is sought to be enforced. And in both areas, in both cases, the respect of the parties' agreement is important, as well as respect for basic notions of due process. And that introduces a troublesome area in international commercial arbitration. If there is let's say a Magna Carta, a constitutional provision in international commercial arbitration, is that all arbitrators have to respect at least two basic rules. One is to treat the parties equally and giving the parties an equal chance to present their case. And the other one is to give each party a full opportunity to present the case. What does it mean, full opportunity? What does it mean, equal treatment? Well, ideally, it should be almost 100% equal. Sometimes it doesn't happen that way, and that may be a subject to challenge. Sometimes the opportunity to be heard is not a full opportunity to be heard, because sometimes there are appeals, there are challenges that are not admissible in arbitration for the sake of making arbitration more expedient and more cost-effective. So it is on the part of the arbitral tribunal the very careful duty to balance, on the one hand, the right to be fully heard and due process of law, on the one hand, the need to make the arbitration cost-effective and expedient and speedy. Those are two problems, and there are many examples where the lines are really gray. Now, what if the parties don't agree? What if the parties fail to reach an agreement on a certain point? Well, in that case, again, almost a universal rule is that it is for the arbitrators to decide what would be the suitable procedural rule in that matter. And that, again, is a widespread rule. Well, those seems to be very easy rules then. Party autonomy, and in the case the parties fail to reach an agreement, the arbitrators decide. And that is actually how the most arbitrations are actually governed in the world today. There is a thin possibility that there could be disagreement, that the parties may fully agree on a certain procedure, and the arbitration panel find that it's not actually conducive to a cost-effective, speedy arbitration. Who decides if the parties are unable to reach a compromise on that point? Well, I guess that in principle, most arbitrators in practice will go along with whatever the parties tell them to do. Ideally, however, it would be good if the presiding arbitrator at least would have the authority to say no if the parties were to ask for a 2-week hearing when the arbitration really shouldn't take more than 1 week, or if the parties would not allow this reasonable amount of discovery when the arbitration panel finds that some amount of discovery is necessary in order to unearth or discover part of the truth. But again, this is the exception. These are the tough calls. And at times, the arbitrator may have to say, as I said, go against the will of the parties. And generally, they rarely would do so. Now, how do an arbitration panel in an international commercial arbitration actually exercise this almost full discretion given by the law? And I think that it's a great diversity in the manner in which arbitrations are actually conducted and the way evidence is being taken. On the one hand, because that's what the rules allow them, the arbitrators, to do. They don't want to have an inflexible, rigid rule applicable to all arbitrations. And in generally, the type of procedure, the type of evidence taking will be subject to what I think I would list in at least 4 criteria. One and foremost is what is the expectations and desires of the parties. And I think the arbitration panel has the obligation to take that definitely into account. Secondly, I think it's very important the nature of the dispute. You cannot handle a dispute of a $50 million dispute the same way you handle a $100,000 dispute. So I think that the nature, the amount of the dispute, the complexity of the case also will make the evidentiary rules and the procedural rules vary. Thirdly, I think the background and expertise of the arbitrators. And if that one feature in arbitration of an arbitration panel is that you would have arbitrators made out of people coming from different backgrounds, different experiences, different nationalities, different legal cultures. That definitely will give a different imprint to the arbitration. The way in which I find in practice this taking of evidence steps develop is in the first place by calling for a preliminary hearing. That is what most arbitration panels will do. If the parties are at a great distance, and it happens to be the case in international arbitration, an in-person preliminary hearing will not be possible. It will be too expensive, too time-consuming. So what I think most arbitration panels will do is to have some kind of a telephone conference call or video conference call, whereby the arbitrator will meet face-to-face or at least hear the voices of the parties, giving them the opportunity to know what type of arbitrators they want, the arbitration they want. And it's at that point when you probably want to start, as an arbitrator, fixing the basic ground rules of the arbitration. There is also another opportunity. The International Chamber of Commerce rules provide for what is called a terms of reference. And that terms of reference is supposed at the very beginning of the arbitration. Actually, the rules say within 6 months that the panel received the dossier, the documents, they have to come up with what they call the terms of reference. And in the terms of reference, they will set out the different timetables, a provisional calendar, the type of hearing they want to have, the type of issues that are actually genuinely controverted, and that then will serve as the basis of the award, because generally those issues that are listed in the terms of reference as the controversial ones are the ones that the arbitrators would have to address by force at the time of drafting the award. In arbitration practice, I see that at least in complex arbitrations, what the arbitration panel will do is, in addition to have a terms of reference, in addition to have a provisional calendar, which are required by the rules, they probably will draft what is called a procedural rules. And I wonder, and sometimes I objected to that, and I said, is it really necessary? Can't you have the procedural rules in the terms of reference, where you're going to put all the elements of the guidelines of the arbitration? And then I realized that is a good reason why the procedural rules are drafted. Because if it's true that it's impossible to give an absolute full hearing, full opportunity to present the case, because there will be unavoidable limits to the timing that the parties have to present the case, why not make them sign and expressly agree that these are going to be the rules of the game? So at the end of the day, when we come out with an award, and one of them complains that their procedural rules were not giving them enough timing to present the case, well, you can at least say, but you did agree with these procedural rules, and these are the rules that we agreed to have. So it is common practice today in complex arbitrations to have procedural rules drafted by the tribunal in consultation with the parties, and have the parties sign those procedural rules. Now, in practice, of course, what the tribunal will do is to invite the parties to draft their own procedural rules. And what probably some tribunals may do is to send an email or a letter to the parties saying them, the tribunal will see welcome if the parties were to agree on such and such points of procedure, just in case the parties forget to agree on some point. Generally, in my experience, I've seen that the parties, especially with experienced counsel on arbitration, they will sit down, talk about the type of procedure they want, and they will agree on the procedure they want to follow. It would be exceptional to find, or inexperienced counsel, where they would struggle and fight about small things. I think that most advisors and counselors would really disagree on very important matters, which they would prefer to submit to the tribunal, but most experienced lawyers will agree on and will reach an agreement, knowing that if they don't, the arbitration tribunal would come out with its own rule. So what we would have is a procedural order at the very beginning, establishing what the procedural rules are going to be, on top of these terms of reference or procedural rules. Now, one document in which lawyers can find quite helpful assistance is if you look at the Int'l notes on how to organize arbitration proceedings. They're a little bit dated. They were drafted in 1996, but they could give a good checklist, and they're on the website of Int'l, about all the issues that you should take into account when you start thinking about organizing an arbitration, including the language, if the parties haven't agreed, the seat, the way that communications will be handled, the addresses where the communication should be addressed, the question of the evidence, the timing of the evidence, fact witnesses, expert witnesses, when will the hearing take place, which is a very, very important matter, how long it will take. Issues of costs also may come up at that very early stage. How long will an opening statement take place, if at all, if there will be opening statements? What about post-hearing statements? Would you want them oral post-hearing statements, or do you prefer written post-hearing statements? Well, these are areas in which parties may disagree. It's good to give them an opportunity at a very early stage to agree on those points. And I think that once those ground rules are set, the arbitration is likely to develop more smoothly than would otherwise be. Now, this of course doesn't mean, even if you have rules, that the arbitration, the taking of evidence, would be followed in the same way in all arbitrations. Again, it is probably the background experience of the arbitrator that I will give a different hint or a different color to the arbitration. I listed, for instance, in the common law and civil law divide, is likely that the civil law trained arbitrator is likely to have more bias towards this inquisitorial, so to speak, approach, in the sense that it's the tribunal's duty to investigate the truth, even if the parties don't make such a good job, as opposed to the common law, so to speak, adversarial mode of approach for procedure, where the protagonists are the lawyers, and the arbitrators rarely interfere with what the lawyers come up with. These are two different styles. Definitely you will see it in almost all arbitration panels. Sometimes the differences are one of degree. And I do think, and that's why the title of the conference, that some legal systems strongly influence the other. For instance, I've seen in international commercial arbitration, even civil law lawyers trained in the so-called inquisitorial mode, they let the space, give the floor to the lawyers to actually handle most of the cases, and they will rarely interrupt or take up, as the civil law judges would, take up the lead in the interrogation and investigation of the truth. There is a matter of degree, I agree, but there will be differences in that point. There will be differences also depending on the temperament of the arbitrator, their ego, their time commitment, their more or less experience in the matter. Some of them like to be very interventionist. Other colleagues of mine prefer to have a hands-off attitude, and unless one of the lawyers breaks the rules, they will not ask questions. They will prefer the parties to run the show, and the arbitrators only at the end will have questions. But I have other arbitrators who will be the one who take the lead. Fortunately, we have some rules, so-called soft law, not mandatory for sure, that are also helpful, other than the usual notes that are referred to. One of them, very little known, is a so-called Ally UNIDRA rules on transnational civil procedure. This is a set of rules prepared by one international organization whose seat is in Rome, the International Institute for the Unification of Private Law, known as UNIDRA. They joined forces with the Americans, who have an American Law Institute, and about 6 years ago, 5 years ago, they came out with the so-called rules or principles on transnational civil procedure. They're meant to be a combination of common law and civil law approaches to issues where there are differences of views, such as discovery, examination of witnesses, documentary evidence. And they came out with quite useful rules. But in practice, these are the rules least known. The most known rules, and mostly used by arbitrators all over, are the International Bar Association rules on the taking of evidence in international commercial arbitration. They were originally drafted in the 1990s, now in 2010, also available in the website of the IBA in several languages, are a set of, in my view, extremely helpful rules that bridge the gap between common law and civil law on many procedural issues. And those rules, most lawyers and most arbitrators would like to adopt it as guidelines. Very few arbitrators and very few lawyers would like to be bound by the rules. They generally say, we adopt those rules as guidelines unless the parties agree otherwise, and unless the arbitration tribunal decides otherwise. I think that in my practice that are generally they are followed. They are well drafted, I think well balanced in the way they are being drafted, and I hardly ever find much of a problem with the handling of those rules in international arbitration. One good example of it is discovery. In the question of how much information one party is bound to disclose to the other, the civil law and the common law do not share the same view. traditionally civil law countries, be it because they consider to be infringement of privacy, or because they think that no party should be bound to declare against himself, like a sort of a privilege against self-incrimination in criminal law. There are no tools in many civil law countries to extract information from the other party who is not willing to give it to it. Whereas in the common law, especially in the United States, discovery is much used and for some people even abused. Where Article 3 of the international rules of the ABA provide what seems to me a good balance between the two, because in cases in which the information is really relevant, it's in possession of the other party, and the information that is likely to be extracted is likely to have an impact on the outcome of the case. In those cases, you can have a request to produce, which the other party will contest by some privilege or saying why that information should not be disclosed, and then the arbitration tribunal decides finally which arbitration should go or not. And I find that even my civil law colleagues like it, when it's to their advantage, to have an arbitration tribunal that has the power and say, disclose those cards, because without that information, the claimant is not going to have a case. In that case, I think, again, there is much to be learned from the discovery, if taken in a modest way as it has been. But I warn you, when I said discovery, I use it in the way that probably also we civil lawyers know about it. Discovery of documents. I haven't talked about interrogatories, pre-hearing interrogatories, or let alone pre-hearing depositions. But I have had arbitrations in which both parties come from the United States, and both parties want to have pre-hearing depositions. They find that it would be a violation of due process if they didn't have a chance to have the depositions. And sometimes they want to have interrogatories too. I think that is much frowned upon by international arbitration. It would, in my experience, is rare the case in which an international arbitration tribunal will grant the possibility of having interrogatories or deposition. But discovery of documents is another matter. Insofar as witnesses, and I'm going to finish with this, both on the fact witnesses and on expert witnesses, there are divisions of view on that area. On the one hand, the idea of telling the witness what to do, what to say, coach the witness, is very much, again, not very wide respected in civil law jurisdictions. The witness is supposed to be very spontaneous, and nobody's supposed to coach him before doing that. Well, the arbitration rules of the IBA say that to coach a witness does not necessarily mean to impair their credibility or their objectivity. And on the other hand, even though civil law lawyers will tend to find that a party's representative can never be a witness, because witnesses by definition are supposed to be impartial, objective people, not parties. Well, international commercial arbitration have adopted the common law view that parties can be witnesses and can be fully interrogated with the same freedom as you interrogate any third party. That is not acceptable in most civil law jurisdictions, where the means to discover information from a party is more limited. It's just to answer yes or no and a certain type of very formal questions, and you don't have the opportunity to fully interrogate a party witness. In the international commercial arbitration, you can do that. So far as experts is concerned, and with this I close, there is another big difference. What you see in the common law world is a well-known battle of experts, where each party appoints its own. What you see in the civil law world is an expert appointed by the court, to whom the court believes is really the only neutral, objective expert. What do we have in international arbitration? Both. You would have the parties' opportunity to present their partisan witnesses, but then the tribunal, if he or she wishes, will have its own appointed witness. In experience, I rarely see any arbitration tribunal appointing its own expert. Generally, they rely on the expert party witnesses and on the aggressive cross-examination of the parties. To conclude, I think, and I very much would welcome, of course, your comments and your questions about the many experiences that you must have had with arbitration. We have in international commercial arbitration a sort of a hybrid of common law, civil law approaches, where I think one has very much learned from each other, as much as I have learned, of course, from what I've heard in this forum. Thank you very much.
We have another about close to 15 minutes for questions, so if anybody has questions, I would ask you to take the microphone, state your name and your question. Thank you.
Chair, Nick Davidson, Professor. Thank you. In our system, the obligation by way of discovery is treated as sacrosanct, absolute, and counsel's responsibility. And in fact, it was a striking off offence if you did not discover properly and you had cause to make incomplete discovery at one stage. And probably still would be if it was a deliberate act, of course. In the last 10 years, my view is that discovery is not taken so seriously in our ordinary context in New Zealand and sometimes in Australia. And in international arbitration and litigation, where you have many parties in different countries involved, the assembly of the proper discovery, particularly that which is adverse to your client's case, is getting harder and harder. And my own impression is it's not being done well or completely. And so you get an incomplete process as the result. What is your experience in international arbitration about meeting that obligation of discovery and how it's conducted by counsel?
Thank you. Discovery, I expect it to be an important issue of discussion today, and I think, it's refreshing to hear that discovery is taken very seriously in some jurisdictions. And my experience again is that because of an arbitration being international and being the blend of different legal cultures, the discovery obviously is not, first of all, not automatic. International arbitrations, I would say that probably the idea is that there should be no right of discovery unless one party makes a good case that the evidence sought is relevant to the outcome of the case. And even in that case, in my own experience, I've had a hard time, and I'm now conducting an arbitration that has yet to be finalized, in which there are two companies in Latin America, the parties involved. Counsel are Latin American counsel too. In neither country, discovery is allowed. Yet both, one of the parties requested discovery. And I thought as a presiding arbitrator that it was warranted. Yet I noticed that my co-arbitrators, coming from a different jurisdiction, were very uncomfortable with the idea of forcing one party to provide information that that party was not willing to give. So my experience is that if you have an arbitration with a civil law party and the panel is composed with civil law arbitrators, the probably discovery is not going to definitely be taken as such an important tool as it is in domestic arbitration. But again, that's one advantage of the IBA rules. The IBA rules would allow you as a party and as an arbitrator, you find that it's justified, as I do in some cases, to come up with a very well-organized request to produce, with giving the other party the chance to contest that request to produce, either because there is a privileged information or some other grounds which are listed in the IBA, and then finally you come up with a response. Discovery of documents only has become so useful in complex commercial arbitrations that most parties use what is called a Redfern table. Redfern is the name of a well-known British arbitrator who come up with the idea that in complex arbitrations, the issue of which documents should be disclosed and on which grounds you could be exempt from disclosing the document is so complex that it's a good idea to come up with a table where on one vertical column you put what is what you want and why you want it, and another vertical column, what are the hundreds of documents that you object to present if you object as the other party. And then in a third column, the decision of the tribunal as to which one of the two parties is right. That shows that somehow discovery is gradually getting a foothold in international commercial arbitration. But you shouldn't expect it to be the same way as it is used in a common law jurisdiction. One important question, and with this I finish the question that you posed, is what weapons are there to sanction a party that doesn't comply with the discovery? Either because incredibly saying that it's not under his possession or that the document has been destroyed, or just coming up with any other excuse. Well, the only tool that you have is the possibility of inferring that the document that you fail to produce, it's inimical or against the interests of the party you're representing. I see, however, that arbitrators are very prudent and very careful of using that weapon, but it is there and at least is a sufficient threat, other than subpoenas and contempt of court that you would do in your own country, to actually compel the discovery procedure.
Thank you very much.
Nicole, then if you could pass it back to Robert.
It's probably quite a specific question, but have you seen a practice
Nicole Smith.
Nicole Smith. I do mainly international arbitration from New Zealand, but I was in London for 9 years, or 12 years, sorry. When do you consider that discovery or disclosure should occur in an international arbitration? And in particular, do you think it should occur before or after the first primary witness statements filed by each side? The reason I ask that is because from the arbitrations I've been in, there doesn't seem to be a standard practice. And it becomes very important if documents are disclosed that for the tribunal to make a decision, the witnesses ought to deal with those in their written evidence prior to the hearing.
Thank you. It's a very relevant question. It has the question of the timing of the request to produce documents, it related to the question of the timing of the witness declarations. In the first place, it is very common in international arbitration today that the witness declaration be done in the first place in writing. So when you have a witness statement, which will take the place of a direct examination, where the witness will provide basic information that the party who is presenting it wants it to present. That witness statement is likely to be submitted at the very beginning of the arbitration, together probably with the first submission, with a statement of claim and with a statement of response. And therefore, it only after, and your question points to this issue, only after you read the witness statement that you may be aware of a document that it may be relevant to the outcome of the case. In that case, and I think in many complex arbitrations, you have this situation, it is appropriate for counsel at the very beginning to make clear that there will be a second round possibility for a request to produce documents, and that second round will come up after the first witness statement is done. And in that case, then you would have the opportunity that you want to avail yourself of being able to request documents that you were not aware of without first having heard it. Now, what happens if you don't have witness statements and the only declarations of witnesses you have are witnesses declaring in voce at the hearing itself? That's a more complicated matter, but in a very recent arbitration, that situation came up with one witness coming up with a board of directors resolution that nobody have heard of before and apparently was very relevant for the decision of the case. Well, one of the parties asked us to the tribunal that they wanted to see that board of directors resolution. Providing that is not subject to confidentiality or any privilege of that nature, we as arbitrators decided that because the rules give us the opportunity to request documents at any point before the rendering of the award, we thought it would be appropriate to take upon ourselves, after hearing this witness, to request the parties to produce. But we were hesitant to say that we were doing it because one party requested it, because that party did not say it at the very beginning. So the other party could well have told us, this is not timely. They should have done it before. But since we have that opportunity to request documents until the end of the award, we felt that free to do that, and I think it would be probably conducive to a better award.
Robert Fisher, Auckland. Professor, thank you for your ideas from international arbitration, from which I'm sure domestic arbitrators can learn. I get the impression that it's rather more a smorgasbord of procedural ideas across both international and domestic arbitration, and that we all borrow from each other to try to do the best, rather than simply tapping into the way things are done internationally and adopting them. But the one thing you mentioned which did make me nervous was the invitation to the parties and their lawyers to work out the procedure that they wanted and then to effectively present that to the tribunal. My own experience, for what it's worth, is that on average, arbitrators are older and more experienced than the lawyers appearing before them, and generally think they have something useful to contribute as to what is going to work best. And if anything makes me uncomfortable, it is the lawyers presenting me with a package of procedures, and often even their attempt to select what are the relevant issues and then present it to me as a fait accompli. And you then find yourself presented with a straitjacket in which you find that you'll have simultaneous exchange of evidence and submissions rather than sequential. You'll have a rigid timetable without a safety valve to deal with the inevitable unexpected. You will have a good faith attempt to identify the issues which invariably were the wrong ones, and that it is far better to have a conference at which you work through these things and hope to contribute something.
Good point. I think that at the end of your comment, you said that what you would prefer is to have a conference. Because in the conference, the arbitrators can voice out what they think is best and what they may, even not letting the whole procedure be conducted by whatever the parties wish, which is what makes you nervous. My experience is that most arbitrators will go along with the type of procedure that the parties submit to them under the guise of saying, well, if that's what the type of justice they want, what can I do about it? I think that it would be, as I said in the presentation at the beginning, it's good for the arbitrator sometimes to say, no, this is not conducive to a cost-effective, fair arbitration, which I want. But it's a difficult situation. The comment that you made at the end of having a conference with the parties, I find it ideal. Because in the conference, you can then ask the parties, do you really think, counsel, that that's going to be better, having two weeks of hearing? Couldn't we do it with less? What about presenting 13 witnesses about the same statement of fact? Could you select amongst those 13 witnesses 3 or 4 that can provide testimony in the same way? And probably asking that question aloud in front of the counsel from the other party will probably get you the better procedural rule that you want. Whereas if you just simply do, as I believe most arbitrators do, including me, is to by asking the parties to present the tribunal with their procedural rules, you will get a fait accompli. This is it. This is what we want. And the parties, the arbitrators rarely would have the opportunity to say no. So it's a good idea to confer with them.
Just got a question that I've been wanting to ask. Bob mentioned the word straitjacket. Some procedural rules that I've seen effectively give the parties a very strict timetable within which to present their cases, even down to witness A will have 30 minutes or 35 minutes, counsel will have 15 minutes for cross-examination, and then very strict amounts of time for presentation of argument. And I understand that you might even use the equivalent of a chess clock to keep people to time. Can you just give us a few comments about how that works and whether there's any party resistance to it or counsel resistance? And
we never had resistance to the fact that if the parties agreed on a 1 day of hearings, they have to agree whether we'll start at 9 o'clock or at 8 or at 10. Most hearings will start at 9 or 9:30, whatever, and they will end at 6 o'clock. And if it's Monday through Friday, definitely that amounts to a certain number of hours, total number of hours. So if our duty is to give each party equal time, it's a great concern from the tribunal to keep a close eye on the timing. So what we generally do as a matter of practice is, as I said, there could be more than one way of doing it right, is to divide the whole allocation of time in two and say you have so many hundreds of hours or dozens of hours to present your case, and you have so many hours to present your case. What I've seen is sometimes the parties have disputed. Some parties have said, well, what we want is no more than so many hours for fact witnesses. And because we think that the expert witnesses are more important in this case, we want to give them more hours. The other party is saying, let me determine how much time I want to spend with my fact or expert witnesses, which I believe is a position that tends to prevail. What we finally say is, these are the numbers we have, we have a chess clock to control that how much time each party has used. At the end of the session every day, we tell the parties how much time they have consumed, how much time they have left, so they know about it, and we don't get on Friday at the last minute with big problems of someone not having been heard enough. And we let them spend as much time as they want with one witness, if that's what they wish. But they should know that if they spend so much time with that expert, they won't have time for the other witnesses. But there's no other way to do it. I think the culture may play a role. When I was visiting, we had a very interesting visit to the Supreme Court of New Zealand the other day, and I understood the very kind host telling us that in the Supreme Court practice, the lawyers are not strictly, that don't have strictly to adhere to a certain timing. As in the United States Supreme Court, they have no more than 30 minutes to give their arguments. And I said, well, that would be unthinkable in arbitration. We cannot give the parties as much time as they wish because there is a limit. And the limit is fixed by them when they say 1 week of a hearing, which is generally is expensive enough, even for expensive cases.
I think we'll draw to a close there. It's 25 to 4. You'll need your coffees. I'd like you to thank Professor Garra for me. He's produced a very entertaining and informative session, and thank you all for your contributions.
Thank you.